All right, everybody, thank you for watching this video. This is Dana Robinson. I'm a 20-year trademark attorney, and I developed, co-founded trademarkbank.com. We offer a really cool tool for docketing your trademark. That means you won't miss any deadlines, and we're going to tell you what happens at each stage of your trademark's life. We also give you a watch tool so you can watch for other trademarks. And we've got a cool search that the USPTO database doesn't have. So check out trademarkbank.com if you haven't already. If you're already a user and you're getting this because you got a trademark refusal, this is your tutorial on how to address a trademark refusal on your own without having to hire a lawyer, hopefully. Let's walk through this. So we want to talk about what to do if your trademark gets refused. Most people, and maybe this was you, file a trademark and think they're done, right? But the reality is that when you submit the trademark application, it's just the beginning of a very long process. And about half the time, the trademark is going to get refused, at least initially. And so you're probably at that stage. And let's talk about what you can do if you had a preliminary refusal. So when you file a trademark, you have about 6 months before your trademark even got examined. It got assigned to an examining attorney. This is a trademark lawyer that just does this all day long, examines trademarks. And they assess your filing and they look at some things like, is it similar to any other trademarks that have been filed? Is it descriptive or generic? Is it otherwise something that should be refused, or is it something that they feel comfortable letting through? And like I say, more often than not, we feel that trademarks are refused. But here's the cool part. If this is your first round, your first rodeo, it's a non-final office action. So the most common non-final refusals are something that you just have to deal with. And you could certainly hire a lawyer, and in some cases you may want to, but we want to at least give you the resources to see if you can deal with this on your own. And so hopefully you got a notice from Trademark Bank telling you to check out this video so that you could at least take a crack at it. So here's the cool part. The refusal is not the end of the road. Most people actually get the refusal, don't know what to do about it. They paralyze and they don't respond at all, and then the trademark goes abandoned. Hopefully that's not you, and you're going to respond to the trademark after you watch this video appropriately and maybe salvage your trademark. So there are two categories of refusals: substantive and informalities. If it's an informality, then you're in luck. Informalities are just technical problems. We call them informalities, which is funny because I kind of think they should be called formalities. So informalities are good usually. It means it's something you can fix. They didn't like your logo, the file format, it had grayscale or color in it. They want a disclaimer of something or a foreign word translated. So a lot of things, and these can be resolved very quickly by you in writing, by email. You can use the submission process itself that the USPTO gave you a link to when they gave you the refusal. And you can even call the examiner, and in some cases ask them over the phone to amend with what they call an examiner's amendment. You just say to the examiner, please translate that word into this, and they will do that for you. So informalities are pretty awesome. I'll give you an example here. We got Hot Diggity Dog Restaurant. You'd be asked to disclaim the word restaurant because you can't claim exclusive right to the word restaurant, and so they might have you disclaim that word, and that's a simple informality that you would address either in writing or over the phone. In other cases, there might be a more formal refusal. If you filed on TIS Plus, the cheapest way to file, and you forgot to translate a word, there are a few things where they will ding you financially. So some of these will be easy to fix, but require you to pay the $50 extra, I believe. So depending on when you're watching this video, that's a possibility as well. But these are all things that are usually easily resolvable, don't require a lawyer, and will save you $400 or $500 on lawyers if you just deal with it yourself. Now here's the thing. Our system, if you've got your trademark in it, will remind you. Trademark Bank's going to ping you a few times through the process up until the 3 days before your final due date. Don't neglect this. Take care of it right now as soon as you're done watching this video. Call the examiner. It's the phone number, and often their email is in the refusal. So go look at that refusal that you got in the email from the USPTO and see if you can call the examiner. They often don't pick up their phone the first time. A lot of them cyber commute and don't know who's calling. So leave them a message, leave the serial number. For example, if it's an informality, you can tell them what you want to do on their voicemail, and then they'll call you back knowing exactly what they want to do, and that makes them feel more efficient. So that's easy way to address informalities, save yourself some money. Substantive refusal is a little more difficult. A substantive refusal is more complicated legal grounds that are an inherent problem with your trademark. We'll talk about a few of the biggies, but just because you got a substantive refusal doesn't mean it can't be overcome. People pay trademark attorneys like me and my law partners to do this kind of thing all the time. So we argue with the trademark office over whether they're right or wrong, and sometimes they'll accept that. I've seen trademarks that have been argued by non-lawyers that are very informal and not very technical, and they still convince the examiner that there, for example, isn't a likelihood of confusion between two marks, or the mark isn't descriptive, or whatever. I'm going to talk about the two most common grounds for refusal. The first one is what they call likelihood of confusion. This is pretty common, and it's pretty challenging to overcome in some cases. It's that your trademark is too similar to a previously registered trademark or a previously pending trademark application. So I use the example here of Green Tree as the name of a construction company. You might be refused because there's a landscape maintenance company called Green Tree. And you're entitled to argue this, and there's no harm in trying. It doesn't cost anything to argue. As if you do it yourself, you can do that, or if you pay lawyers, they can do it for you. For example, with Green Tree, if this was a real life example, it's not, I've never done a Green Tree trademark, you would point out that there's a lot of other green trees. There's a Green Tree landscape, there's one for plumbing, for example, there's a solar installation, another for an electrical contractor, and you would argue to the examiner, well, this is a crowded market. There are a lot of green trees in the construction space. There's no one big giant green tree that owns all the rights. So there's room for me, is what you're going to argue. And you don't necessarily have to cite cases for this, although you can certainly go look up other people's arguments. You can actually go find briefs I've written. They're public documents. You can see my arguments, and you could even mimic those and just say, oh, I found a trademark attorney. I found their likelihood of confusion arguments and poach the basic logic and some of the cases, and then make your own arguments. So you, as a non-lawyer, could probably save $1,000 to $1,500 if you can convince the examiner that you're right. Now, keep in mind the document that you submit is public, so whatever you argue will bind you in the future. We call that file wrapper history estoppel. Complicated way of saying once you let the cat out of the bag and you make an argument that it's not likely to be confused, then you can't argue the opposite later. So if you make this argument, then when another green tree comes along, you're going to have a challenge objecting to their trademark. But that might be okay. If you're entering a crowded market with a lot of green trees in your space, then maybe you're not going to care that someone starts a green tree business as long as they're not using it for the exact same services you are. So whatever those arguments are, keep in mind that they become public record. That's good and bad. It means that you can see what your competitors have argued. It means you can find great arguments from other people, their lawyers. But it also means whatever you disclose in your trademark application process is there forever and will be used against you if you ever go to assert your trademark rights. The second most common ground for refusal is merely descriptiveness. If your trademark is refused based on being merely descriptive, that means that the trademark isn't registrable, at least not until it becomes well known. Take green tree, if you sell green trees, then the trademark office would say, well, you can't trademark Green Tree for selling green trees. If it's for a construction company, then it's suggestive. If it's for a plumber, it's suggestive. They're not selling trees that are green. They're suggesting with their trademark that there's something eco-friendly, for example, about them. So the trademark that's refused based on merely descriptiveness can be overcome as well. It just takes a little bit more art and finesse in some cases to argue, because here's the thing. If you argue that trademark is not descriptive and it's suggestive of the quality of the products or whatever, for example, you might shoot yourself in the foot, because if it's misdescriptive, that's a different refusal. So if you argue that the trademark is not descriptive in a way that's very strong, you also might end up boxing yourself into saying that the trademark is essentially misdescriptive, and then they'll come back with a whole nother refusal. So the art here is arguing that the trademark is suggestive without necessarily saying that it's couldn't possibly ever be used to describe anything about the product or service. So I try not to be highly emphatic when I'm making these arguments, because I'm trying to really show what's intended in the mind of the consumer who sees this trademark, rather than making emphatic arguments with the trademark examiners. There's a lot of other grounds for substantive refusal. Genericness is a very difficult one to overcome. This is where the trademark is literally for the thing. You can't trademark the word computer for computers. You can argue, if they say it's generic, that it isn't generic, it's descriptive. And if you argue that and you've used the descriptive trademark for 5 years or more, you might actually be able to argue that it has become distinctive of you. You'd file a declaration, what's called a 2F declaration. You can find this when you go into the responsive forms for filing this response online, and say that your trademark has become distinctive over the course of 5 or more years of use. So genericness can be overcome, although it's challenging. Failure to function as a mark is pretty common. That means that, for example, you have a trademark that's not used as a trademark logo on a shirt here, doesn't function as a trademark, whereas a pocket, arm, hang tag, or shirt tag, those function as a trademark. So sometimes it's a matter of just resubmitting your specimen and showing the right specimen, because you might use your logo on your shirt, but you might also use it on the tag. And so you're using it as a trademark right here and as an ornamentation right here. So that's a ground for refusal, again, that can be overcome sometimes without a lawyer. You can have geographic terms that get refused as well. As with other refusals, there's no reason why you can't at least try to overcome these refusals. If your trademark got refused on any substantive ground, you could do a little bit more research as well. The USPTO website has a lot of helpful information. Trademark Bank tries to put out a lot of helpful information. I have courses on Udemy and LinkedIn Learning about trademarks as well. So a lot of these things can help arm you with the tools that you need to do a DIY, non-lawyer, self-represented response to your refusal. All right, so what if you get refused? Obviously, you can engage an attorney or you can do it yourself. I've seen lots of people argue on their own without attorneys and win. It's my profession, and so I like doing it, and my team is happy to look at trademarks that have been refused and make our best shot at it. Typical informality is pretty fast and easy, and so I always recommend people try those themselves. But for a more substantive refusal, there could be a lot of finesse that's required. So it depends on your financial situation. I love this example. I found teaching a class once, and I was looking for self-represented people, and I found a guy that had filed for candy called Turds, Turdz, and he got refused on the basis that this word was scandalous. The trademark office is actually changing its policy right now on whether something can be refused as scandalous under free speech rules. But at the time, it was scandalous. And Bob wrote his own argument. I don't remember his name's Bob. But his argument was great. It was like one page, and he said he just thought it was cute. His kid brother came up with the idea, and they both thought it was funny. So that argument prevailed. The examiner said, fine, we're going to let this through. And all they needed was a good faith argument. So just arguing that turd seemed cute, fun, non-offensive didn't mean that it was scandalous. And so Bob got his trademark through. And so there's lots of ways you can do the same. Take a crack at it. If you're nervous about what you can say or do, like I said, you can look up other trademarks that have been filed by trademark attorneys, by companies, look up a competitor and see if they had a trademark refused, and look at their response. You can actually just download the PDF of their pleading, their arguments, and see whether those arguments might be something you can use as well. Ultimately, look, not everybody's comfortable with their doing this themselves, and if your business is financially viable to the tune of paying $400 to $1,200 to have a refusal addressed by a lawyer, it's always better if you've got the resources. I mean, Trademark Bank exists to empower people who own trademarks, whether they're small law firms or individuals or corporations, and resources can be scarce, right? So I put this tutorial together because I want you to be able to take a crack at this rather than lose your trademark altogether. And again, if you have the resources, then don't leave anything to chance and pay somebody who's professional to take a look at it and make your arguments for you. What happens next? Well, if the examining attorney disagrees, you'll get a final refusal. You can respond to a final refusal but they can just ignore it. They don't have to respond. They can just say, done. We're not rehashing this. If you get a final refusal, you could then take it to an attorney and see if the attorney can request reconsideration and appeal it. And that might be available to you depending on the arguments you made in the non-final refusal. Now, in terms of our service, remember that we send a reminder when the trademark gets refused and let you know if there's any change in the status after you have filed. So if you get a refusal after the time you file your office action, then Trademark Bank is going to shoot you a notice for that as well. You get your notices at the regular intervals, unless you use a custom notification system that we've built in as well. So keep an eye on this. Don't miss your deadline. That's what this is, all about. You're paying a small fee to be sure that you don't miss those important deadlines and wake up 2 years down the road and realize you missed something and that your trademark is dead at the time when you really want it to be alive. With that, thank you very much for watching the tutorial, and we'll see you in the next round of tutorials.